Challenge to appointment of an arbitrator. This video is brought to you by W Practical that works to provide quality, accessible legal training across India. Independence and impartiality of an arbitrator are the hallmarks of any arbitration proceedings. Appointment of an arbitrator can be challenged on two grounds. First, if circumstances exist that give rise to justifiable doubts as to his or her independence or impartiality. Second, he or she does not possess the qualifications agreed upon by the parties. Section 12 of the recently amended Arbitration and Conciliation Act 1996 requires that a person who has been approached for a possible appointment as an arbitrator disclose in writing the circumstances which are likely to raise justifiable doubts as to his or her independence or impartiality to act as an arbitrator. This disclosure must be made in the form specified in the 6th Schedule of the Act. Such disclosure is in accordance with internationally accepted practices to be made applicable for arbitration proceedings commenced on or after October 23, 2015. Non-disclosure can lead to serious consequences for the arbitrator, including termination of his or her mandate, even if he or she has not been assigned work or given remuneration for the concerned part. The challenge to the appointment has to be decided by the arbitrator himself. If he or she does not accept the challenge, the proceedings can continue and the arbitrator can make the arbitral award. The grounds stated in the 5th Schedule serve as a guide to determine whether circumstances exist which could raise justifiable doubts as to the independence or impartiality of the potential arbitrator. On the other hand, the grounds specified under the 7th Schedule render a person ineligible to be appointed as an arbitrator. The 5th and 6th Schedules of the Act have been inspired, albeit not fully, by the three internationally recognized lists provided under the International Bar Association Guidelines on Conflicts of Interest, that is, the Green List, the Orange List, and the Waivable and Non-Waivable Red List. Let's look at the procedure for challenging an arbitrator. The parties have freedom to contest the competence of an arbitrator in any form. Where parties fail to agree on a procedure to be adopted in challenging the appointment of an arbitrator, an aggrieved party who intends to challenge an arbitrator shall, within 15 days, challenge the constitution of the tribunal. The aggrieved party shall submit a written statement addressed to the tribunal in order to contest the appointment of any or all the members of the arbitral panel or tribunal. The tribunal can make a decision on the same. If the said arbitrator does not withdraw from his appointment, or if the other party does not concede to the objection raised by the aggrieved party, Section 13 of the Act provides liberty to the parties to agree on a procedure for challenging an arbitrator. However, if the parties are unable to reach an agreement for the said purpose, a party who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal, or after becoming aware that circumstances exist that give rise to justifiable doubts as to his or her independence or impartiality, or he does not possess the qualifications agreed to by the parties, send a written statement of the reasons for the challenge to the arbitral tribunal. The arbitral tribunal is required to decide on the challenge. If the arbitrator does not withdraw from his office and the other party does not agree to the challenge. In case of failure of challenge, the arbitral tribunal shall continue the arbitral proceedings and make an arbitral award. Where such an award is made, the party challenging the arbitrator may make an application for setting aside such an award in accordance with Section 34 of the Act, and if the award is set aside on such application, the court may decide as to whether the arbitrator who is challenged is entitled to any fees. Let's move on to termination of mandate of an arbitrator and substitution of an arbitrator. In Section 14 of the Act, it is provided that the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure or de facto unable to perform his functions or for other reasons fails to act without undue delay, and he withdraws from his office or the parties agree to the termination of his mandate. If a controversy remains concerning any of the grounds referred to in Clause A of subsection 1, a party may, unless otherwise agreed by the parties, apply to the court to decide on the termination of the mandate. If under this section or subsection 3 of section 13, an arbitrator withdraws from his office or a party agrees to the termination of the mandate, shall not imply acceptance of the validity of any ground referred to in this section or subsection 3 of section 12. Section 15 provides additional circumstances under which the mandate of an arbitrator shall terminate. These include where the arbitrator withdraws from the office without any reason, or by or pursuant to agreement to the parties. It is further provided that where the mandate of an arbitrator terminates, a substitute arbitrator shall be appointed. The same rule shall be followed in appointing a substitute arbitrator, which were applicable to the appointment of the arbitrator being replaced. Where an arbitrator is replaced, any hearing previously held may be repeated at the discretion of the arbitral tribunal, unless otherwise agreed by the parties. However, it is provided that an order or ruling of the arbitral tribunal made prior to the replacement of an arbitrator shall not be invalid solely because there has been a change in the composition of the arbitral tribunal, unless otherwise agreed by the parties. Let's look at one of the landmark cases, Steel Authority of India versus British Marine, which was in 2016. The question of law that arises here is for the determination of this petition filed by the petitioner, Steel Authority of India, against the respondent, British Marine, under Section 14 of the Arbitration and Conciliation Act. The question is whether the court, in exercise of its powers under Section 14(1)(a) of the Act, can declare that two of the three constituting the arbitral tribunal are unable to perform their functions, and therefore their mandate should be terminated and they should be substituted by two other arbitrators. According to the facts, an agreement was entered into by Steel Authority and British Marine. This was amended by addenda. The agreement was for import of coal from Australia to the extent of 3 million tons plus or minus 5% during the period from June 2008 to December 2012. British Marine invoked Clause 60 of the agreement, which provided for arbitration under the Act or any further amendment thereof, and under the Marine Arbitration Rules of the Indian Council of Arbitration. The rule further stipulates the Maritime Arbitration Committee shall be the sole judge of the grounds of the challenge, and its decision shall be final and binding on the parties. After invoking the arbitration clause, British Marine filed its statement of claim and nominated Mr. Niranjan Chakraborty from the Maritime Panel of Arbitrators of the Indian Council of Arbitration. By an order in 2014, the Maritime Arbitration Committee of the Indian Council of Arbitration rejected the challenge of SAIL contesting the appointment of Mr. Chakraborty on the grounds that he was not a commercial man as required by the agreement. On May 2014, Steel Authority appointed Mr. Ashok Sharma as his nominee arbitrator. Further, in 2014, Mr. Chakraborty, while accepting to serve as an arbitrator, made a declaration that I did not have financial or personal interest in the outcome of the award, which is likely to disqualify me as an impartial or independent arbitrator. Later, the Indian Council of Arbitration appointed Captain S.M. Berry as the third or presiding arbitrator, and the arbitral tribunal was thus constituted. Steel Authority filed a statement of defense contesting the claim of British Marine. The case of Steel Authority is that where there was a claim made against Steel Authority by Sea Spray Shipping Company Limited, which came to be adjudicated by the arbitral tribunal which composed of both Mr. Chakraborty and Captain Berry as co-arbitrators. According to Steel Authority, the questions involved in the present arbitration and those in the arbitration in which the award was made in favor of Sea Spray and against Steel Authority were more or less identical. According to Steel Authority, the Sea Spray award gave rise to justifiable doubts as to the lack of independence and impartiality of Mr. Chakraborty and Captain Berry. Steel Authority requested the Maritime Arbitration Committee for an oral hearing of its application. This was rejected by the Indian Council of Arbitration. After considering the submissions of both the parties and carefully going through the relevant facts and circumstances of the objections filed by Steel Authority, the Indian Council of Arbitration decided to dismiss Steel Authority's application by a speaking order on the ground of delay. It is stated by Steel Authority that a copy of the speaking order was not provided to it despite a request being made. The court was informed during the course of the hearing of the present petition that in the arbitration proceedings, evidence of the claimant, that is British Marine, has been included and cross-examination of his witnesses by Steel Authority has already been completed. While rejecting Steel Authority's request for a copy of the speaking order, the Indian Council of Arbitration informed Steel Authority the relevant mandate of the Maritime Arbitration Committee regarding its objections cannot be made available even to any of the Indian Council of Arbitration members, let alone the parties concerned, except the committee members who can only inspect the minutes. With effect from October 23, 2015, an important change took place when the ordinance to amend the Act was issued. The ordinance had since been replaced by the Arbitration and Conciliation Amendment Act 2015, which came into effect on the same day. Important changes were made to Section 12 and 14 of the Act. As far as Section 12 of the Act is concerned, it had been recast to provide for a person who is approached in connection with his possible appointment as an arbitrator having to mandatorily disclose in writing the circumstances which are likely to give rise to justifiable doubts as to his independence or impartiality, as given in Clause 1, subsection A, and the circumstances which are likely to affect his ability to devote sufficient time to the arbitration, and in particular his ability to complete the entire arbitration within a period of 12 months as according to Clause 1, subsection B. Explanation 1 to subsection 1 of Section 12 of the Act as amended states that the grounds stated in the fifth schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. Under Explanation 2, it is stated that the disclosure shall be made by such person in the form specified in the sixth schedule. It may be noted that even under Section 12, subclause 2 of the unamended Act, the arbitrator was required to disclose the parties in writing from the time of his appointment and throughout the arbitral proceedings without delay any circumstances referred to in subsection 1 unless they have already informed of them by him. Section 12, subclause 3 of the Act states that an arbitrator may be challenged only if a. circumstances exist that give rise to justifiable doubts as to his independence or impartiality, and 2. He does not possess the qualification agreed to by the parties. Section 12, subclause 4 states that a party may challenge an arbitrator appointed by him or in whose appointment he has participated only for reasons of which he became aware after the appointment has been made. Section 12(5) has been inserted by the Amendment Act where, notwithstanding any prior agreement in view of the relationship of the person with the parties or counsel or the subject matter of the dispute as specified in the seventh schedule, such person becomes ineligible to be appointed as an arbitrator. This, however, can be waived by the parties by an express agreement between them in writing. Section 14 of the Act talks about the failure or impossibility to act. Barring the small change in the Amendment Act to provide that the arbitrator would be substituted by another arbitrator if his mandate terminates in accordance with the provision. Section 14 more or less remains the same. Mr. Mukhopadhyay, senior leading counsel appearing for the petitioner Steel Authority, at the outset stated that there are two broad grounds on which Steel Authority is seeking termination of the mandate of both Mr. Chakraborty and Captain Berry. One of them is on account of acting in defiance of the statutory obligations to make a full disclosure in terms of Section 12 of the Act, which according to him results in their de jure disqualification, precluding both of them from functioning as arbitrators. It is conjectured that by their conduct of refusing to make a disclosure, both of them become de jure or de facto incapable of performing their functions as arbitrators in terms of Section 14(1)(a) of the Act. Secondly, it is stated that a situation under item 24 of the fifth schedule exists in the present case, as both these arbitrators participated in the sea spray award, which involved similar issues and therefore gave rise to reasonable and justifiable doubts as to the lack of independence and impartiality. Mr. Weishist, learned senior counsel appearing for British Marine, first submitted that the petition is an abuse of process of law. It was filed by Steel Authority only to delay the conclusion of arbitral proceedings, which is at an advanced stage of evidence of Steel Authority. Consequently, Mr. Weishist points out that for the purpose of the fifth schedule, and in particular item 24, a party cannot seek disclosure of something which is already within its knowledge. In the present case, Steel Authority was itself a party to the Sea Spray Award, which was issued by a three-member arbitral tribunal comprising of both Captain Berry and Mr. Chakraborty. It cannot therefore be said that Steel Authority was unaware of those proceedings. Before examining the above submissions, the court adverted to the scheme of the Act as far as the challenge of the arbitrator is concerned. If a challenge under any proceeding agreed upon by the parties or under procedure under subsection 2 is not successful, the arbitral tribunal shall constitute the arbitral proceedings and make an arbitral award. It may be mentioned that the above judgment was followed by this court in MBL Infrastructures Limited versus Telecommunication Consultants India Limited, which has been stayed by the Supreme Court. It is submitted that the decision for the purpose of Section 13 of the Act had to be taken by the arbitral tribunal itself and could not have been delegated to the Maritime Arbitration Committee of the Indian Council of Arbitration. As already noticed, the decision of the division bench of the court in Progressive Career Academy Private Limited versus Fiji Limited has not been challenged in the Supreme Court and still holds good. The court does not have the option of not following the said decision only because an SLP is pending against the subsequent decision of the learned single judge in MBL Infrastructures Limited versus Telecommunications Consultants India Limited. The scheme of the Act in Section 5 therefore does not permit interference by the court in arbitral proceedings and intermediate stages unless expressly permitted by other provisions of the Act. Hence, the court is not persuaded by the submissions of Mr. Mukhopadhyay in the present case that it should intervene to terminate the mandate of Mr. Chakraborty and Captain Berry and replace them with two other arbitrators. The reasons are as under. First, the essential scheme of the Act regarding challenge procedure has not undergone change, even after the amendment to the Act with effect from October 23, 2015. Second, the parties have consciously agreed that the arbitration would be governed by the Maritime Arbitration Committee rules, in terms of which the decision of the Maritime Committee rules on the challenge to the arbitrators is binding and final on the parties. The Maritime Arbitration Committee has negated Steel Authority's challenge to both these arbitrators. Having failed in such challenge, the Steel Authority has necessarily to wait for the passing of an award to raise a ground to challenge such award, assuming it is adverse to Steel Authority. In other words, one of the grounds to challenge under Section 34 of the Act is the challenge to the impartiality of it. Let's look at two more relevant case laws. TRF Limited versus Energo Engineering Projects Limited. In this case, the respondent is engaged in the business of procuring equipment for installation in thermal power plants. The respondent had issued a purchase order in favor of the appellant and received certain bank guarantees from the appellant to secure performance of the purchase order. Certain disputes arose between the parties and the appellant invoked arbitration on December 20, 2015. The appellant had objected to the procedure for appointment of an arbitrator provided under the purchase order and sought an appointment because the specific terms of the purchase order. The respondent rejected this contention of the appellant and appointed an arbitrator by way of its letter dated January 27, 2016. Thereafter, the appellant filed an application under Section 11.5 read with Section 11.6 of the Act for appointment of an arbitrator under Section 11.2 of the Act. The High Court stated that if a party to a dispute had been validly conferred with the right to appoint an arbitrator under the old Act, then the same was not usurped by an application of the amended Act. The High Court further stated that the Amendment Act provided for a detailed list of ineligible criteria of arbitrators under the 7th Schedule to the Act, none of which is mentioned that the right to appoint an arbitrator under the old Act would be subsumed by the application of this amended Act. The issues here are, if a person authorized under a contract to act as an arbitrator becomes ineligible by operation of law, whether he would be eligible to nominate another person to act as an arbitrator. And second, whether a plea seeking statutory disqualification of a nominated arbitrator can be raised under Section 11.6 of the Act. In this case, the Supreme Court ruled that a court can be approached to plead statutory disqualification of an arbitrator under provisions of the Arbitration and Conciliation Act 1996, and that it is not necessary to approach the arbitrator for obtaining such a relief. Further, the court held that when the designed arbitrator nominated under a contract is also responsible for the appointment of an alternate arbitrator, he or she would lose his or her authority to preside and or nominate an arbitrator if he or she stands disqualified under the amended provisions of the Act. The second case is HRD versus Gale. According to this, Gale went into a contract with HRD Corporation, Marcus Oil and Chemical Division, on 1st April 1999 for the supply of wax generated at Gale's plant for a period of 20 years. A similar dispute arose between the parties on various occasions, and consequently HRD invoked the arbitration clause in the agreement at various times. In total, 4 separate arbitrations took place. The present case before the Supreme Court concerned the 4th arbitration. Justice Lahoti's appointment was challenged on the following grounds. Item 20 and 22 of the 5th Schedule to the Act were applicable, thereby giving rise to justifiable doubts as to his independence and impartiality. Items 1, 8, and 15 of the 7th Schedule to the Act were applicable, thereby making him ineligible to act as an arbitrator. If appointment of Justice Dorbier is bad, then the appointment of Justice Lahoti is also as bad, as an ineligible arbitrator cannot appoint another arbitrator. Justice Dorbier's appointment was challenged on the ground that items 1, 5, and 16 of the 7th Schedule were applicable, thereby making him ineligible to act as an arbitrator. Here the Supreme Court propounded that certain important principles of law, such as if an arbitrator had passed an award in an early arbitration between the same parties about the same dispute, that does not mean there are justifiable grounds for challenging his impartiality under Clause 16 of the 5th Schedule, while a challenge based on the 5th Schedule can be decided only based on the facts of the case and can be brought before the court post-award. One based on the 7th Schedule renders the arbitrator ineligible ipso facto and can be brought pre-award. However, in such cases, the application for setting aside the arbitral award can be made to the court under Section 34 of the Act. If the court agrees to the challenge, the arbitral award can be set aside. Thus, even if the arbitrator does not accept the challenge to his or her appointment, the other party cannot stall further arbitration proceedings by rushing to the court. The arbitration can continue and challenge can be made in court only after the arbitral award is made. Thank you for staying tuned. For more information, contact us at lawdocs.in.